court rise.
Yes, Mr. Brandreth.
My lords will have gathered before the short adjournment that one of my submissions is that the difficulty with reading the judgment is to be focused on the issues that the judgment was concerned with rather than what was an issue at trial. I realised that before lunch I was guilty of the same error, and in particular in response to my Lord Justice Birss's queries about that page of the insight analysis. I forget that I have been over that document 100 times, that it was dealt with in cross-examination where its effect was accepted by the witnesses from Tesco, but of course my Lord Justice Birss is seeing it for the first time. And I was also in error in not drawing your Lordship's attention to what is said by the judge about this particular document in her conclusions on unfair advantage and value at 175. I should have begun there.
175.
175 is page 611 of the bundle. And I should have begun there because the conclusion that I rushed to is expressly set out there, and it would have been obviously very helpful for somebody seeing it for the first time to have understood it as it was explained in evidence, and my apologies for forgetting that the problem of knowledge. But you see there, she's explaining at the beginning, I consider the evidence confirms that Tesco chose the signs with a view to them having brand significance and influencing their consumers. I find the process of developing the new club card prices promotion began in 2019, the focus by Tesco on value perception, including specifically with a view to winning back the Wicks. In the summer of 2019, so this is, it must, we say, be a reference to the insight analysis, which is from the summer of 2019, that's the only document she can have in mind, particularly when you see what she goes on to say. It was recognised by Tesco that it needed to work harder to convince consumers of the value of its products compared to those of competitors. The addition of the Tesco logo on advertisements resulted in consumers rating Tesco lower for value than its competitors, including Lidl. I should have begun there, my lords, but you see that this evidence is part of the reasoning that informed her judgment.
Yeah.
My lords, what did the judge actually do? If we turn within this bundle to page 487, we are again in the grounds of appeal. Having set out at paragraph 2 why Tesco suggests no reasonably circumspect and well-informed consumer would conclude that the signs showing a club card price in fact indicated a price match with Lidl, they turn at paragraph 3 to explain why they say the judge erred in finding that in fact they would. And here we may take up matters in our own skeleton argument, which is behind tab 26. It begins at 523, but it's at 525 that we begin to address those propositions in paragraph 3 of the grounds of appeal. And at paragraph 9 of our skeleton, we set out what we say are a number of citations from her judgment that in our submission make it clear that the judge was proceeding on the basis of her impression and using the evidence as a way of confirming that impression in the light of particular points made by Tesco. To the references I have already given in paragraph 9 might now be added the further citations that I have taken you to this morning in the context of the distinctiveness of the wordless mark, where, for example, she expressly states the evidential matters are in common with her own impression. But I might also draw your attention to paragraph 146 of the judgment. Here, Her Ladyship is considering the evidence of Miss Farrant and asking herself what can be extrapolated from that evidence. And the reason I draw it to your attention is that she is alive to the issue of whether a particular view can stand for that of the average consumer, and in this context, she rejects that proposition.
Yes.
One of the questions that comes out of all of these references in the judgment is a challenge for Tesco. Why do they suggest that there are good grounds for thinking that the judge would not have found infringement but for the evidence that they criticise, when we suggest that the judgment is clear and consistent in showing that the judge considered on every point relevant to a finding of infringement that Lidl's case was sound, and simply used the evidence, as I say, to check the impression in the light of Tesco's contentions to the contrary. She was well focused, we submit, on explaining in detail where her conclusions lay on particular points in dispute, and that's well illustrated by an argument that is made by Tesco in their skeleton argument at paragraph 24, where they're expanding on paragraph 3 of the grounds of appeal. What they say there is that the allegation that the judge erred by departing from the simple approach of applying her own common sense and understanding of the world, and then considering if it was contradicted or confirmed, and instead approaching the case as if it had to be answered by the evidence, can be seen from the structure of the judgment. First point, they themselves do not point to any express reference that shows that what they say happened did happen, in contrast to us where we say the express references are to the contrary. They rely on the structure. We say the structure is revealing to, but against them. And that is because she starts at paragraph 99, and the analysis that they reference in their skeleton argument, that is at page 588.
Sorry, just a minute. We're going to 99.
Yes, I'm sorry, my lord, I went too quickly. Paragraph 99, page 588. And what we have here is a section that has begun link on paragraph 96. And the observation she's making at the outset, as you see at 99, is that all of the intel factors can be dealt with swiftly.
Yes.
Because all of them are present. In beginning her analysis with a paragraph in which all of the factors identified in Intel Corp as suggesting the existence of a link are said to be present, and then proceeding to address further evidence, we say that the structure reveals that the judge was using the evidence not to derive a conclusion that would otherwise be unexpected, but to check whether her assessment, which the classic Intel factors all pointed towards, was in some way to be controverted by the other evidence. In other words, the structure suggests she's done the very opposite of what Tesco say she has done. Can I also ask you to pause there? Having held that all of the factors in Intel were present, the suggestion that she would not then have concluded there was a link unless driven to it by the evidence we submit is unsustainable. That's the point that we make at paragraph 14 in our skeleton in this case. Notable, we say, by its absence is any suggestion in the judgment at this stage that she is unable to or disinclined to conclude there is a link causing detriment or unfair advantage, and therefore needs to consider the evidence. Nowhere, we say, does she suggest her conclusion is finely balanced or had to be tipped by the evidence. To the contrary, when one looks at her conclusion on link at 147, what she sets out as her conclusion is that, and here I should quote, I consider that the average reasonably observant consumer encountering the signs in the real world at the date of the launch of the Club Card price campaign would draw a link between the use of the CCP signs and the mark with text, and that the available evidence amply bears out my conclusion. In other words, the evidence here is not driving the conclusion, it is supporting it, that conclusion being one that follows from her own impression and the Intel factors. There was a suggestion, I think, my lords, which I may already have touched on, that she never draws those threads together with the further question of the damage, the detriment and the unfair advantage. And I promised to take you to where I say she does that expressly. That, we say, is to be found at 174 in the context of unfair advantage, although my lord appreciates that we also submit that it is something that followed in her mind from the background of evidence that we have already looked at this morning as to the inherent effect of the use of the little logo. And what I draw to your attention at 174...
Well, yes, that 174 certainly against the backgrounds of my findings so far, but the question I was asking you was, did she ask herself, does the use of the sign convey the price match message?
What she says in 174 is that she considers that it takes unfair advantage of the distinctive reputation which resides in the little marks for low price discounted value, and that is because that is the terms in which we have put that in our pleading at paragraph 24 as the consequence of the link that she had already found, and that link of course being one of price matching, and we say that that was something that flowed naturally from all of the previous evidence that we have looked at. I cannot say that there are in terms a statement along the lines of expressly by reference to price matching.
I mean, if you go on to 176,
yes,
she says that the signs were intended to convey value.
yes,
But I think in dialogue with my Lord Justice Birss, you accepted that wasn't enough.
indeed. But the way that it was put in the pleading, and that we say is the manifestation of the price matching, is that the unfair advantage manifests itself in this way, and so that by expressing herself under the heading of unfair advantage, in the same terms that at paragraph 24 of our pleading, we had said that that price matching would manifest itself, it must follow that she understands, not least from the evidence we saw this morning, that that is a price match connection that consumers are making from the awareness of the use of the sign.
And that is based, is it solely on the evidence? Because she never says that's what it conveyed to her, as far as I know.
No, the reference to link is the one that she says conveyed to her. We say the fact that it doesn't expressly talk about price match there is nothing to the purpose, because the nature of the link that was being advanced was one of price match. Right. So by saying that she accepts there was a link, she is then saying that it manifests itself in the way that we said the unfair advantage would manifest itself in paragraph 24. But if my Lord
wants to discuss price matching in some detail in the succeeding paragraphs.
Indeed. And again, as I say, the issues that were canvassed at trial were specific to the question of whether or not any link would arise in the first place at all by virtue of things like the club card prices and the reference to Tesco. And that if one is to descend to the point where one is looking for specific wording, then we fall immediately into what I would say my Lord Justice Lewison has said is not what should be done in the appellate court, and that there is nothing in this judgment that is inconsistent with her having found, as we had pleaded, as the evidence supported, and as we say, was the only plausible basis for the finding of detriment and unfair advantage that she says she considered existed.
I mean,
And indeed,
would it
in
be
that
fair,
regard,
Mr. Brandreth, forgive me, would it be fair to characterise the judge's findings, say 174,
yes,
as that the unfair advantage resides from taking advantage of Lidl's reputation and value?
yes, I think it would be fair. I mean, it's express, I think. So yes, but I anticipate
Is that a legally relevant unfair advantage?
it is, my lord. We say
Surely it needs to be a misrepresentation, and for it to be a misrepresentation, Tesco could be offering value, but they don't necessarily offer a price match.
indeed, and where the unfairness comes in is because it has arisen from the link that she has found to my client. It is not from a general perception that Tesco is offering value, but specifically that they are offering value by reference to my client's reputation for value as a discounter. I do understand. I think my lord's concern. You're saying you've got to join all of the dots.
Yes.
And I'm saying that she has joined all of the dots, but I have to accept that she hasn't spelled it out in those terms, because the analysis has been done by reference to the elements of the cause of action, link and unfair advantage. The expression of unfair advantage has been done in terms that were, as we set them out in our pleading on unfair
Well,
advantage.
you referred to your pleading, but your pleading was more, if I may say so, more careful in that respect, because it did specifically plead a case based on price match, not value. Whereas this isn't your pleading.
No, the
Your
link
pleading is better than that, if I would put it that way.
well, I wish I could take credit for that, but that would be someone behind me. But my lord, the point I'm making is that the paragraph on link and price matching is 22. The paragraph on unfair advantage is 24. And what we're saying is that the link leads to this unfair advantage. And the judge has done what she ought to have done, namely to look at what the pleaded case was and ask herself whether or not it's true.
I think that's right up to a point, except that you are a bit more specific, aren't you, in your pleading?
Yeah.
22, which is what you say the link is very specific.
Yes.
Tesco's use of the sign is so as to suggest that the prices of those goods offered by Tesco under the sign are offered at the same prices or lower prices than could be obtained for the same or equivalent goods at Lidl.
I think the point I'm trying to make is to address what I understand is the challenge, namely, should she have said in terms that the price match led to the unfair advantage?
Yeah.
All I'm trying to explain is why
Doesn't she come pretty close to saying it, for example, at 180? As Lidl points out, the immediate problem caused by the link between the Lidl logo and the CCP signs is that consumers think that they do not need to check if they can get a particular product in question cheaper at Lidl, because Tesco have already checked.
Indeed. And I have already mentioned this morning that one of the debates at trial was whether or not, in fact, on analysis, you didn't get better value at Lidl. And the passage that my Lord Justice Arnold has just taken you to goes on, is in the context of consideration of that debate. And the reason I think that I'm drawing attention to the difference between 22 and 24 is to explain, or to offer at least one explanation for why it may be that there is no single sentence or paragraph that joins the dots in the way that my Lord Justice Birss is asking, has that been done? Because she understands that that's how it works within the flow of the overarching argument.
I quite see. If that is the link, if the link is as pleaded,
Yes.
then I can see that the unfair advantage follows.
Absolutely. But she's found there is a link on the basis.
In her own assessment of link,
Yes.
she's found there is sufficient similarity for the sign to call the mark to mind. I don't think her own assessment, her own independent assessment, I don't think goes any further.
What I would submit to you is that she has in several places said that she thinks it's similar in her own consideration.
Yes.
But specifically at 147,
147.
conclusion on link, which in my submission must be the link that we have pleaded, is that there is such a link, would draw a link, and that the available evidence amply bears out my conclusion. And of course, in that context, it is, I'd say, supportive that the issues of evidence that she looks at include the question of whether there was a price match going on and it was understood, because otherwise the evidence wouldn't be bearing out that conclusion, or at least wouldn't be bearing out that part of the conclusion. It comes down to, in my submission, the absence of an error of principle and a desire that perhaps it had been expressed differently in a judgment. That's not a basis for an appeal. So, my lords, I want to turn to the specific criticisms of the evidence, but there is this question of principle, and I can take that, I think, extremely quickly, because the only one that it seemed to me survived my learned friend's oral submissions was the idea that you should be cautious about the approach to the evidence, and I've given what in my submission are multiple references that show that the judge fully understood that and was doing that. And the second one being, and I'm not even sure if my learned friend does go this far, but a proposal almost that the judge should, in a clean room, come to a conclusion before any consideration of the evidence is given at all. And one thinks perhaps of an analogy with a patent expert being shown the patent before being shown the prior, sorry, rather the other way around, prior art before being shown the patent. If that is his suggestion, then in my submission, that should be rejected, because not only is there no basis for it in authority, but it would be plainly impractical. The suggestion that a judge can engage with the ultimate question on infringement before becoming aware of any evidence not only precludes the judge from having any role in the decisions as to what is or isn't admissible on that evidence, because by that route she becomes aware of it, but secondly, precludes the possibility that the evidence is itself necessary in order to understand what the circumstances of the average consumer are. Moreover, as we understand it, the task of the judge is ultimately to put herself into the mind of that notional average consumer in giving her own view. Inherently, it is considered to be something that a judge is capable of doing. If that is so, then that is a filter that she must be taken to be capable of applying as she encounters the evidence as well. And indeed, in this case, my lords, you see that the judge has done precisely that. I don't spend any longer on it than that, because the debate on principle, we say, whether we win or lose on it, is not reflected in any error by the judge. Can I turn to the specifics of the evidence? I deal with them in the order in which they were presented in the skeleton argument. And the first of these is the H&P report. We've touched upon it, and it may be that I can move through it quite quickly. That is one that Tesco raised in their skeleton, paragraphs 15 onwards, and they make a number of points about it. It perhaps helps, my lords, just to have in mind what is meant by out-of-home advertising, which was of the kind that was the focus of discussion.
These are posters, TV ads. I think there were some radio commercials.
Well, radio commercials wouldn't be part of out-of-home. I think they were separately. Out-of-home was a specific category of advertising, and the only thing I was going to do was very quickly draw your attention to Miss Farrant's evidence, because at page 60, you can see that, and on the left you have the Tesco advert, and on the right you have one of my clients' adverts. So just to give you some understanding of what we're talking about there. Now the point that we make in our skeleton argument at the outset is that when she comes to the evidence, one of the issues that she questions herself on is whether or not each of the pieces of evidence is internally consistent with the other pieces of evidence. In other words, she is asking herself, do they all point in the same direction? Not just as to the ultimate conclusion of that evidence, but also as to the causal mechanisms that are operating. Is it the same thing that is leading to the people who identify the Lidl sign when they see the CCP sign? Is it the same things that they reference when they talk about price matching? And we say that in my learned friend's submissions, both orally and written, he fails to acknowledge the significance of that. We say that it's absolutely the correct role for a judge to take, because she ought to be examining whether or not there is something that is an outlier by virtue of being distinctive from all of the other evidence. The way my learned friend seemed to put it was that that process tainted each piece of evidence. We say that that can't be right. Now, the first criticism that's made by Tesco of the H&P report is that it didn't meet the Whitford guidelines. I don't think that criticism survived my Lord Justice Arnold's question to my learned friend. And certainly we say that's quite right. The judge did consider what could be extrapolated from this evidence and thought that it could be extrapolated out because it was something that was specifically designed to test consumer attention. The second criticism they make as part of that criticism, I should say, they are endeavouring to suggest that the judge used this H&P report to answer the ultimate question on section 10.3. And one of the points we make in our skeleton argument is that we don't understand her to be using it for that particular purpose. Its special significance is that it showed evidence of confusion between the CCP sign and Lidl in the percentage in out-of-home advertising. As we know from Intel, the presence of confusion is itself an indicative factor. But in this particular case, my lords will recall one question that's risen again and again is, when people refer to Lidl, do they actually mean Aldi? And what was helpful about the H&P evidence is that it was expressed in saying, no, they mean Lidl. It's Lidl that they're thinking of. And my learned friend took you to the document there. I'm not going to take the time of the court to show you. So that the evidence of confusion was confirmatory not only of the judge's conclusion that there was sufficient similarity to give rise to link, but rather also of the question, is the link a link to my client, to Lidl? And that's why we say that once one appreciates the significance of the evidence to aspects of the question that ultimately feed into the decision on 10.3, the second criticism, the one that we address at paragraph 18, namely whether confusion remained operative in the minds of consumers after the initial one, it misses the point. That's not the purpose of this evidence. It's not testing that question. It's testing another debate that was going on at trial. The third point they make is that the judge fails to grapple with the significance of the context of the confusion arising. We disagree. We say she expressly addresses it at paragraphs 104 to 105, and that's on page 589, the core bundle. And we say her response is clearly correct, but certainly cannot be said to be rationally insupportable. This is the point, my lords, within the context of this, to discuss what we say is a repeated equivocation by Tesco, one that we've highlighted in our skeleton argument of paragraph 22. Tesco did not intend to be mistaken for Lidl. We say that that is different from the question, first, of whether the existence of confusion, even though they didn't want to be mistaken by Lidl, is probative of the issue of linking. But we say you can tell from intel that it is. More than that, as I say, when Tesco's experts, H&P, are asked to explain why the confusion is arising, what they point to are precisely the factors that we say are at play, namely that the sign looks like the Lidl logo. The second point we make is that not wanting to be mistaken for Lidl is quite different from the question of wanting to improve your value perception. And my Lord Justice Birss has pointed out the need for passing off a deception of some form. And we say it's there that the deception lies, but what Tesco are pointing to in their argument is a different deception, not one that we advance. The next issue, my lords, is the Vox Pop.
Just before you leave
Yes.
the H&P,
Yes, madam.
I'm struggling to know whether 8% has been regarded as a big number or a small number.
I think the answer, my lord, is that it wasn't being regarded as an important percentage at all, in the sense that it was to thereby indicate how many people would draw the link, or whether or not it was enough to count as substantial for the purposes of passing off. What was significant was that here you had a Tesco advert, blazoned with the word Tesco, with the word club card across it. And yet, even in those circumstances, there was a percentage of people that understood that this was the Lidl sign, to the degree that they didn't even notice the Tesco signage or the club card signage, such as to make themselves think, oh, this is actually Tesco, not Lidl. And that was probative of underlying questions within 10.3. So I don't think that the number was, sorry, my submission is, the number was not important in the sense that one might have asked oneself, is it enough that 8% of people are drawing the link? That is not.
As you pointed out, she discusses that question explicitly in the context of passing off at 275.
Indeed. And what we say is that she's very, very cautious about quantitative assessments that can be made from this material.
But that's what bothers me about
Yes.
this is if it was 99%, you'd be jumping up and down,
I'd have done 10.2, my lord.
and if it was 0.1%, no one would have cared. Why isn't? What I'm worried about is that this number is being given significance because this whole point is being given significance, and that depends on taking a view on whether you regard 8% as significant or not.
My first
And
submission.
this inherently does. This must be an exercise of deciding that that is significant. I don't mean statistically significant. That's what I'm talking about.
Absolutely, my lord. 2 points. The first is, in my submission, 0.1% would have been enough because of the point I made earlier, where the proposition by one side is a strict one, namely nobody would think that, then the presence even of 0.1%, we say, may well be indicative. But I agree with you.
But that can't be the proposition. The proposition could be no average consumer would do that.
No, my lord, that would be the ultimate question. What I'm saying is that there were within it subsidiary questions, such as whether or not you would consider the sign to be similar at all.
Yeah.
And that they made an absolute proposition on. They said, no, it's dissimilar. It's dissimilar. And so it's why I'm saying it's a subsidiary question. But really, I think the answer is that my Lord has put it correctly. She obviously did consider it to be significant, not in a statistical sense, but in the sense that, as the expert evidence had indicated, where you have got circumstances that condition someone to understand that you are talking about Tesco and club cards, the fact that they still mention Lidl is worthy of note, because it cuts across the arguments that are being made by Tesco that nobody would ever do so because of the presence of the word Tesco and club card.
But that's an Aunt Sally. Nobody would ever do X, or everybody would always do Y. Both of those things don't matter. And judging oneself against that sort of standard isn't what these are ever about. And the fact that this is material which business people will use to make their own business decisions for what they're interested in doesn't mean that it's necessarily of any weight, significance in a court case which is asking an entirely different question from the questions which the business people are making their decisions on.
I absolutely agree with that as a general proposition. But in this case, my lord, the judge was entitled to consider the evidence, having heard cross-examination about it, and to ask herself whether or not she thought she could use it more generally. She concluded she did. Now, it may be that my lord might have come to a different conclusion as to the significance of 8%. It doesn't mean that she made an error of principle in doing so. And as I've shown you, she gave express consideration to whether or not, and to what degree, this evidence had broader significance, and we submit that there was not only no error of principle, but that she was plainly right in the circumstances of this case as it was argued. And my lord may be saying, well, I wouldn't have argued it on the basis that nobody would think that these two signs were similar. Dissimilar. I would have argued it on a different basis. It may well be that my learned friend wishes in retrospect that that's how he had done it. But because it was argued on that basis, this judge had to consider that argument. And that's why my fundamental submission is...
The advocacy is great, but it doesn't amount to what this was used for. It wasn't used to falsify what I've called an Aunt Sally and then move on, which is what you just put it as if you ask yourself the question, would nobody ever think X? And the answer is no. Plainly, somebody would think X, because here is a survey which did something which shows that at least a few people would think something. If you make that decision and then move on, fine. But that's not what's happening in this case. This evidence is being used. Maybe it's partly being used to falsify the extreme point, but it's not only being used for that purpose.
But my lord, I'm saying it is being used to falsify both the extreme point and to test her own perception, as she explains at 100, of whether or not there would be both a confusion and price comparison confusion on the part of the public. I fully accept that she is using it both to test the extreme proposition and to see if it has any consistency with her own conclusion. But I've also shown you that she is careful to ask herself whether she's entitled to do so by reference to the nature of this material. And the answer that she has come to is that she is entitled to do so because Tesco have asked these people, in their expertise, to go out and tell them what the average, in the non-technical sense, the average consumer seeing their adverts thinks. And they've come back and given them answers which Tesco consider to be actionable because they consider them to be accurate. And she thinks to herself, well, that is therefore something that I can rely upon, just as Tesco relied upon it as an indication of how these signs will operate in the real world. And of course, my lord made a point right at the very opening to Mr. Purvis that there is an importance to understanding how these things operate in the real world. And the judge was particularly alive to that because she is being presented with these signs, not in the 2-second passing reference that we understand from the research is how most consumers engage with it. She's not on a bus seeing it passing on the hoarding. She is being taken through it in great detail by clever people who, as you put it, may have good advocacy even if it's all polish no oak. But therefore she's entitled, in my submission, to ask herself, does this help me? And that's exactly what she's done. And that's why I say 147 is important, because she says, this is my conclusion, and it's borne out by the evidence. Not, this is something I didn't think would happen, but the evidence drove me to another direction. So, if I may put it this way, by the way, I completely understand the concerns, I say the judge acknowledges them and has addressed them, and that there is no error of principle underlying them. There is a value judgment on her part, and it's a perfectly plausible one. Indeed, I say an obviously correct one. You don't need to go as far as that second submission to dispose of the appeal. Just trying to decide whether I can take part of the transcript and put it on my business cards, my lord, but probably I'd have to put the whole context, which wouldn't help anyhow. Vox pop, my lord. This we address in our skeleton argument from paragraphs 23 to 26 of our skeleton. As I say here, again, and making this submission, I don't want to repeat the discussion I just had with my lord, because what we say is that her primary use is not to answer the final question, but to assess subsidiary questions. And that is why we see when she addresses it, for example, at 113 to 114, she is being very careful to engage with the details and to assess where she can get there. And I think my lord, in this context, yesterday was concerned that she was again engaged in some kind of statistical analysis because there was a reference to a small number of instances versus a majority. What we submit there is that she's simply, she's not attempting to make some kind of numbers-based value judgment. She is cross-referencing the discussion she has had at 111, where she has identified all of the other ones that she says are the vast majority that cannot be dealt with in the way that Mr. Hing has dealt with them. And it is in that context important to acknowledge the point that she makes at 121, that she considers this to be the tip of the iceberg. And for that, my lord, you also need to see paragraph 49 of the judgment. Sorry, that's on page 570. What one sees, my lord, is that it transpired not only had they not searched the relevant part, but having identified a part of it, they had not then disclosed all of the ones that we submitted were relevant. My lord asked yesterday, what are those in section C? Section C were the ones that my solicitors had found by going back over the original disclosure to look through it more thoroughly. And indeed, my lord, there is another point to be made, which is that the version of the vox pop at the back of the...
Sorry, to explain the significance there, can you help us as to what the other ones were? What are the categories?
Yes, my lord. Can I ask you please to take up supplemental bundle B and to turn to page 615. This was the table of vox pop. It was not the table you were taken to yesterday, which is the one that was attached to the back of my learned friend's skeleton at the trial. The sections identify where the vox pop came from. Section A, Twitter messages. Section B, messages sent to Tesco that were included in Tesco's disclosure. We then said, we're not sure that you've searched your database thoroughly. Please provide that database. We'd like to do it. And we were, after some argy-bargy, given the database, and we did do a search. And then the messages at section C, you see this at the bottom of page 617, my lord. These are the messages that were sent to Tesco, but were initially omitted from Tesco's disclosure. Now, that is not the same point as the one that is made in paragraph 49. The point in paragraph 49 is about the date range. But the other thing that was omitted, we say, when you went to the Tesco skeleton version, are the things that you find at page 624 under section E. And these are the messages that could be extrapolated from the research documents that you see. So some of them you will have seen already when you've been taken to things like the source survey, because they will have been call-out boxes explaining what their conclusions were. But there were also all these other messages. And as you can see, my lord, the messages that you are getting, for example, from the source survey one, is the Lidl price comparison. Has all the info necessary, however, does look too cluttered. Also, that yellow and blue design, I think a lot of people will confuse it with Lidl at first glance, or E20, the Lidl price comparison. And the reason why that's helpful, of course, is that in the context of the source survey, because it was artificial in the sense that it was not real-world examples, it was also able to focus in on eliminating some of the potential alternatives. But even then, my lord, I submit that this judge was very alive to the kinds of concerns that you've raised, and that you can see that at 122, she is giving express consideration to whether or not she can treat all of these people as outliers, and she explains she doesn't think that's the right conclusion and why. And partly the point that she's making there is that it is very difficult after there's been this enormous swamping by Tesco through their huge advertising campaign to then get back to an understanding of what happened, as it were, at the point where the infringement began. But the point I direct you to is the specific point, namely that she is not cavalierly treating this as something that is just to be taken without regard for the kinds of concerns that are raised in interval. My lords, there was specific criticism made of the Aldi versus Lidl point. The judge has addressed it at paragraph 111. They say her reasoning is illogical. In my submission, her reasoning is correct, obviously reasonable. We can't improve upon it. We've picked it up at paragraph 26 of our skeleton argument, just by reference to two of the points made there. But the first point that they made was one that we simply didn't understand. But we think on reflection that the misunderstanding reflects a broader disjunction between what we think Tesco are asserting the judge did with the Vox Pop, namely rely upon it as the sum and substance of the finding on 10.3, versus what we say that she was using it for, which was to test particular propositions within the context of the question of link. That once you understand that she's doing that, then her reasoning becomes entirely comprehensible. They also submit that the conclusion she draws at sub 5 is in some way unacceptable. This is the paragraph that my Lord Justice Lewison paid particular attention to yesterday. And on that, we draw your attention to the point we make in the final part of our skeleton at paragraph 25, that when you have taken into account all the other evidential matters, not now disputed, such as that the wordless mark was highly indicative of Lidl, such as that it was being presented to consumers in the context of special pricing schemes alongside an express price match that targeted the other German discounter. These provide part of the context that allows the inference of a link between the statements that confirm it is the presence of the blue and yellow that prompts the consumer to think of Lidl, and the express statements of belief that there is indeed price matching with Lidl. And again, of course, we say that is consistent as to outcome, causal mechanism, and conclusion with all the other pieces of evidence. Paulson and Berridge, my lords. It's in the context of the Vox Pop that the judge addresses Paulson and Berridge. It's repeatedly suggested by my learned friend yesterday that these witnesses have been selected by which we understood him to be implying that they were cherry-picked because helpful to Lidl in the way that is one of the criticisms that's made in Interflora as to the selection of witnesses in a survey exercise. But as you will have seen from my skeleton argument at paragraph 27, that's page 533, they were not selected in any sense other than that these were the only people for whom we had the contact details and who responded to us. Notably, Tesco had contact details we later discovered for all of the people, and yet they did not call anyone. Now it's worth noting that Mr. Paulson did think that there was a price match because of the sign. That is the passage that the judge quotes in her judgment at 116 and 117. It is, I think, an example of the classic advocacy error of asking one question too many, although fortunately for me, in this case, the question was asked by the judge. There was a suggestion by Mr. Purvis that Mr. Berridge could be dismissed as not average. You'll recall this is because he'd had an interest in copyright law and a trademark dispute. That's not a point that's open to my learned friend. It wasn't taken below, and the judge expressly notes as much at 120. Another point made was that Mr. Paulson was not a typical consumer encounter, but that isn't right either. Mr. Paulson was encountering the sign in the form of an advert from Tesco, and that is a typical scenario in which consumers encounter a sign. The points made against the judge's use of this particular evidence in large part replicate the criticisms already made. They fall to the same responses. We've given those answers in our skeleton argument, starting at paragraph 27, going through to 32. As we say, this again is a manifestation of an error on the part of the judge that they say had occurred, but didn't, namely that she used them to determine the final question. She didn't. The source, my lords. You've been taken to this. As you know, my lords, from the passages from my learned friend's skeleton argument that I've quoted, this was something Tesco themselves considered served to faithfully convey the response of the consumers, though they now criticise the judge for doing so. Despite what they urged at first instance, the judge remained alive to the caution that we say is captured in that reasonable proposition on evidence in trademark matters, which is why, as we point out in our skeleton at paragraph 37, she did not treat the source survey as statistically significant or quantitatively significant, nor did she treat it as being capable of answering the ultimate question on 10.3 itself. But it was an opportunity to test whether or not the average consumer would perceive the CCP sign was similar to Lidl, and whether or not the presence of the word club card or Tesco or the absence of the word Lidl was sufficient to dispel that connection, and whether indeed the link to Lidl led to an assumption of a value connection, and whether or not it was with Lidl or with Aldi. On all those matters, the source pointed in only one direction, and it was in the same direction as the rest of the evidence, and as you've seen, as was likely to be the case, given the background. Sorry, my lords, just one moment. I'm skipping to see if I can cut things even shorter. Yes, this is a point that I think is of value. And could I ask you to turn up the judgment at page 598, please? It's really, I think, to show or to counter something that my learned friend, Mr. Purvis, was suggesting yesterday, namely that the judge's conclusions lacked all evidential basis. What I want to show you is that beginning at paragraph 132, she is engaging with the evidence, and in particular with the expert evidence that was brought forward in relation to what the source survey could show. And the point that is of particular importance, we submit, is the point I've already made in the context of the H&P report, namely that the cross-examination of Lidl's expert witness, Miss Sutton, was directed towards her explanation in her report that here with the source survey you were focused on Tesco and you had selected by priming the survey respondents because you asked them, are you a Tesco shopper, are you a club card shopper, and yet still people are saying this is Lidl. That is the point that the judge makes at 133. She does it on the basis of the evidence that she records at at the top of page 600, which is a quote from the expert evidence. But again, we ask that the court note this. She is expressly in her conclusion at 133 being careful to check whether or not this is in some way inconsistent with the other pieces of evidence. The answer is to the contrary. There was ample evidence on this issue from Lidl's expert, not met by any expert evidence from Tesco, but only by cross-examination. The conclusion one, consistent with all the others. That then leads me to internal warnings. And on that I can be very quick indeed, because I'm not sure that my learned friend even discussed that in any detail yesterday. He says he did, in which case I'd better go over it. But it's quickly done because, again, we say that the submissions in relation to the internal warnings are to the same effect, namely that they were being used as conclusory, when in fact what one can see is that they're being used to test particular propositions, most notably whether or not the signs were considered to be similar. And of course, as you know, the answer was that a range of people, including those whose specialist subject, like the man whose attention was the attention consultant, was that there was a real issue here in terms of similarity. And as I say, the judge expressly considered that at 222 in the context of distinctiveness. And she says, actually, I think I can take this evidence and use it more broadly. There's nothing else to add beyond what we said in an argument at paragraph 38 on page 357. These are pieces of evidence that are being used to address specific contentions. They do so, but they are only a small part of the overall analysis. My lords, I've set to one side the issue of detriment and unfair advantage in the light of the way that the oral submissions developed yesterday. The specific points that were made about detriment in the skeleton argument are addressed in my own skeleton argument. So, for example, in writing, my learned friend suggested that the judgment on whether or not there was evidence of change in economic behaviour depended solely on the evidence of responsive advertising. That's not right. If one reads the judgment, you can see that there was unchallenged evidence from Miss Farrant to the effect of the detriment. There was then the specific question of the responsive advertising, where it said that this should have been dismissed because there was no document from the board meeting at which it was discussed, in which the issue of it being responsive was highlighted. That's because it was in another document that the court was well aware of, because they'd been taken to it not least at the PTR, but which was not raised in cross-examination by my learned friend. In any event, the judge has come to a conclusion on it. No suggestion of an error of principle, plainly one for which she had material that shouldn't be touched. Unfair advantage, my lords, there it said there's no evidence, but of course what my lady says is that she is importing what's come before, and of course that includes all of the matters that relates to detriment, but she does then analyse the question of unfair advantage, and we say she had ample evidence to proceed on. The final point is on due cause, and again I can take that very quickly. 2 points were taken in writing. The first was a point about the test or the level of a challenge that needed to be met on due cause, where it was suggested that by referencing stringency, she had set the test too high. That wasn't pressed in oral submissions, but to the extent that my lords are concerned with it, the answer we say is that when you analyse what Mr Justice Kitchen then was saying, all he's doing is expressing there the requirement for the balance to be struck in the context of a prior finding that there is otherwise a problem, detriment or unfair advantage occurring. It is no different from what is going on, and indeed you can see that the judge is primarily concerned with the Planet Art judgment, which expressly sets those matters out. The other point that they made... Yes.
I mean, it probably doesn't matter in the context of this case, but as you know from the question I asked Mr Purvis yesterday, I was concerned about how an advantage could be both unfair and with due cause.
Yeah.
And I think looking back again at the Court of Justice's judgment in Interflora, they say that if there is due cause, then the advantage is not unfair, which I'm bound to say makes better sense to me than the idea of an unfair advantage, which is with due cause.
Indeed. Indeed, it must follow that if it's got due cause, then it's not unfair. But equally, it may well be said that it also serves the other way around. An advantage that might otherwise be unquestionable, where taken without due cause, becomes unfair. Here, of course, there were multiple layers for addressing both the question of unfairness and the question of due cause. And as you say, my lord, I don't think on this particular case it matters. The only other point was about, in writing, was about the use of the source survey. They said, well, the source recommended this particular sign. You have my submissions in writing on that. Can't help you to the question of whether or not you legally have due cause, but someone for marketing purposes said this would be helpful, particularly in circumstances where effectively what they're saying is it'll be helpful in achieving what we say was unfair purpose in the first place. So it can't take them anywhere. In any event, what it doesn't do is address what we submit is the fundamental question, which is whether or not they were entitled to take the whole collection of elements that they took, because we say that those were things that had already been done on the basis of the copy. My lords, as I said in the opening, I don't think I need to address passing off separately on the basis that the case is now advanced against me, because we don't need to descend into the question of whether on the extreme principle of an approach to evidence.
I'm sorry to
No.
hold you up again. I mean, what the judge says, she comes to the conclusion that there is an unfair advantage before she moves on to due cause.
Yes.
And that's the bit of the analysis. Again, it may not matter on these facts, but what I think she probably should have done is found an advantage,
Yes.
then gone on to consider whether there was due cause. If, as she found, there wasn't, then the advantage becomes unfair. I thought that's the right way of doing it, analytically.
I completely understand that, and the answer in my submission is that there wasn't really any debate that if we got to that point, it would be unfair. Not least because the premise of it would be that they had deliberately adopted a sign that drew upon our reputation in order to bolster theirs without providing us with any compensation for it. So, again, this is my overarching submission, which is that the judge has rightly concentrated her discussion on the things that were in debate between us, not on whether or not, if you've got that far down the road, you're in trouble on unfair advantage. And indeed, in a way, one sees that then manifest itself in this appeal when it comes to copyright. As we will say that my learned friend hasn't taken on board, at least when it comes to his question of substantiality, that we can only have got there having already jumped through a hoop that says this is a sufficiently original work to be protected, and you've taken all of it. I think that's the point that my lord made. A similar issue arises here, I suspect, on the question of the unfairness. Once you've got to the stage where you accept that there is this link of the kind that we're talking about, then the unfairness is baked in, and that's even before you consider the copying and the question of whether or not they had due cause and so on and so forth. But that would be my answer to my lord's question. I was going to turn to copyright.
Well, before we leave the question of passing off, can you help me on this? The way that Mr. Purvis puts his case, as I understood it from the discussion yesterday, is he says the reason why passing off and trademark infringement stand or fall together in the present case is that essentially the gravamen is the same under both heads. And so his submission is that the errors that he contends for with regard to the trademark infringement analysis equally infected the analysis as far as passing off is concerned. Now, one of the interesting things about that way of looking at it is that the judge's analysis of passing off begins by quoting in terms your pleaded case. This is at 266. Including, indeed, price matched in inverted commas, as you pointed out earlier, for what that's worth.
Yes.
And I don't think there's any attack on the finding of goodwill. The attack is on the finding of misrepresentation.
Yes.
And she starts the analysis by addressing the question as pleaded. And then goes through it And as I was observing earlier, it's in that context that she addresses the question of the 8% figure at 275.
Yes.
And as I understand it, the finding is that the representation is conveyed by the signs, and it's false because of the reason she gives in 273, which is that under the club card prices scheme, at least some of the Tesco prices are not as good as Lidl prices, even if that's not true every day of the week for all products.
Yes.
Have I got that right?
I believe so, yes.
Now, what do you say to the argument that the same errors that I argue for in relation to trademark infringement necessarily infect the passing off analysis?
My answers would be the same to those in the context of passing off as I have given in the context of trademarks. Necessarily, one would have to engage with them in a slightly different set of terminology because there are differences between passing off and trademark. At least, for example, as the judge herself acknowledges at 275, the difference between confusion and misrepresentation, but also who is to be confused. It has to be people within the goodwill. But ultimately, the allegation is that you can't extrapolate out from the particular pieces of evidence to a more general conclusion. That I hope I have answered, and I would say would also be an answer in the context of passing on. What I do say is that because she has cross-referred between passing off and trademark infringement, you can see in this context, particularly by reference to the price matching to which my lord has drawn attention, that some of the things that were perhaps suppressed or implicit in her earlier analysis are understood by her here to be express, but again by reference, as she says, to her analysis, for example, on unfair advantage at 177 to 181. In other words, I say that the section on passing off helps me, because it simply adds grist to my main mill, which is that she is doing exactly what my learned friend says she should have done. That nothing in this section counteracts that. To the contrary, it supports it.
All right, thank you. So, just before leaving that, just so as I'm totally clear, as I understand it, you seek to turn it around and say, on the contrary, the passing off analysis confirms the correctness of the conclusions reached on trademark infringement. So you turn it around in that way, but I think I need to test you a little more.
Yes.
Are you in a position, and I think the answer is no, to rely independently on passing off if the trademark analysis is flawed? Because you accept that the two stand or fall together, as does Mr. Purvis. So you're in the same boat as that.
I think that must be right on the fundamental question, which is the one that my Lord Justice Birss has identified, which is there a deception at the heart of both?
Yeah.
The answer must be yes. The only reason I hesitate is because obviously there are things like due cause and so on and so forth, which are not parallel, but I can't see a scenario in which the reason why I fail on trademark is due cause, but therefore I could still win on passing off. I suppose formally that's possible.
Yeah.
But in the terms
formally, but not realistic.
In the terms in which this appeal is now being advanced, it is all about whether or not, as I think has been captured by the queries that the bench has asked him, the judge was entitled to proceed in the way she did, to draw not only the link, but the link through to the deception that underlies both the unfair advantage and the passing off case.
Yeah. Thank you.
So that is my answer. Copyright, unless my lords had any other questions. I think I can take this very quickly. The key error of principle, as we understand it, is identified by Tesco in their skeleton at paragraph 79 at page 516. and there was a lengthy discussion by reference to cases of some venerability that cast this problem in terms of questions of authorship, and I think there was an invitation perhaps to talk in more general terms about co-authorship and so on and so forth. But the fundamental proposition, the error of principle that is said to have occurred here, is that the judge took into account in her assessment of the creative effort matters that couldn't possibly be part of the work that was relied on. And we say that that allegation, that fundamental allegation, is flawed. We say, and I think here I echo a question that was asked by Lord Justice Lewison of my learned friend, we say there is a creative choice in deciding, when creating a new design, to take the yellow circle and to reuse it in the mark with text. This creative choice, along with consequent questions as to how to relate that yellow circle within the composite whole of the new design of the mark with text, is what the judge refers to, and expressly so in her analysis, and that is to be found at page 645 in Core B. 3 references. The first is to paragraph 285, where the judge sets out the evidence of Mr. Unterhalter. And I draw it to your attention because it shows that the judge was alive to the nature of the creation of the work that was relied on at sub 3. It would be surprising, we submit, if, having expressly set this out, she then disregarded it in her later reasoning. Second, paragraph 286. Here we say the judge records what we submit is precisely the argument now presented again by my learned friend for consideration by the Court of Appeal. And its significance, therefore, is to show that the judge was fully alive to the distinction between works that the applicant now suggests she did not carry through into her conclusions on either originality or substantiality. Third, 287. The first reason given for rejecting the appellant's argument is a rejection of the idea of taking elements in isolation and disregarding the significance of their combination. And at 288, she is saying specifically that in her judgment it is the bringing together of the existing yellow circle with the blue background and all that is involved in the artistic decision to do so in a particular way, the combination of colours and shapes, the orientation of the various elements, to quote her reasoning, that constitutes the expression of the intellectual creation of the author of the work. Now, if there were any doubt that she is alive to the need to keep the relative contributions separate, we say it disappears completely from reading 289, where she describes what she understands to have happened and also its necessary consequence. The suggestion that the judge, and when I say necessary consequence, what I mean by that is the limits on the scope of the protectable work that arises from a creative process of this kind. She is conscious of that. And of course that is a point that has emerged in a number of my Lord Justice Arnold's decisions on copyright recently. You only get protection for what you have created. And you have to have created something. But then the infringer has to take that which you have created. And in the way she is expressing herself at 289, the reason why she is acknowledging that is because she is acknowledging that the process that we are pointing to involves creative effort of a limited kind. That is why we say that the judge correctly identifies the real complaint of Tesco in paragraph 288, namely that the work is too simple.
Right, so just before we proceed, as I understand the submissions you've been making, you do not take issue with Mr. Cardigan's legal analysis, which is to say, firstly, for the purposes of subsistence, there must be an author's own intellectual creation embodying free and creative choices. Secondly, if there is subsistence, for infringement, that which is taken must represent such creativity.
Absolutely.
Shortly stated.
That's completely correct, my lord. That is the...
So the question is as to whether the judge correctly applied that legal test.
Completely.
Yeah.
But I think we're here on appeal. The question is, did she understand that? She plainly did. Everybody took it to the same cases. Everybody understood that. She's expressly, as I pointed out at 289, acknowledged both limbs, namely, you've got to have creative effort to get protection, and the protection is limited to what you get creative effort, what you put creative effort in. So after that, my lords, we say it's just a value judgment by the first instance judge as to whether or not what's been done is enough, and she considers that it is. She has specifically rejected the idea that what is being advanced is too simple. She considers, on the basis of exactly the comparison that my learned friend urges upon her, that what has been done does involve the exercise of intellectual creation involving the expression of free choice. My learned friend was asked, is that the right test? Did she do it? He agreed it was the right test. He said, no, she didn't do it. She must have looked at something else. And we say, once you've looked at the judgment, you cannot sustain that proposition because she's aware of the distinction. She analyses it in terms that only reflect what is going on. It does, it seemed to me.
Well,
sorry.
Is there on Mr. Cuddigan's argument, there may be a gap between what she says at the end of paragraph 290 and what she says at the beginning of 291. She's asking whether the mark with text involves the exercise of intellectual creation, and she's dealt with that in saying it's the bringing together of all these elements and so on and so forth. And then she says the mark with text has the originality required by statute.
Yes.
Is there perhaps a missing step there?
No, my lord, because the step that you're looking for is to be found earlier at 289, because there she explains how she understands that combination to have arisen, and it is indeed by the taking of the decision to take one particular existing design and to put it into a new composite whole with all of the creative choices that are involved in doing so. And that is what she then understands herself to be referring to. And of course, my lord, in choosing an existing work that has an existing colour, there is a choice of colours being made by the relationship that occurs there. And that's all that she's referring to, all she can be referring to, having regard to the fact that she understands, as you can see from 285 at 3, what the process was, where the starting point in terms of that central element was. And we do submit in that regard that part of my learned friend's submission is a kind of generalised, how can one ever get copyright for these sorts of things? But of course, my lord, has been taken to her earlier analysis in the context of distinctiveness. And of course, one must be careful. Those are two different topics, distinctiveness and originality. But you do know that in that context, she's expressly said that she doesn't consider the wordless mark, which is effectively the part that was copied, to be banal, trite, or commonly used, which is, of course, part of my learned friend's submissions that underlie his simplicity point. I'm fully aware that one has to be cautious about porting that across because we're not talking about the same tests, and she doesn't expressly do that. But it is relevant that she's said, again, in that context, a specific combination of simple geometric shapes and primary contrasting colours is both memorable and distinctive of trade origin. So you understand here that she has rejected one of the premises of the it's too simple argument, which is that these kinds of things, in their nature, cannot be protectable.
Is there a danger, though, that in expressing the judgment being expressed in the way it is, it appears to give equal weight to the stage 2 artwork and the blue border, the blue background, because they're not the same in this context, because one is a given, and the other is what the artist is adding. The trouble with, forgive me, just finish what I'm trying to express. Yes. The trouble with giving them equal weight, such as at the beginning of 289, is that you could be left being forgiven for thinking that you would infringe the work by using effectively the circle and the little text, but you wouldn't.
I totally understand that, my lord, and of course that is the danger that my learned friend sort of flags up. But my submission to you is that that is not apparent from what she says at 289, because what she understands is that the composite is where it is in the combination that the creativity lies, not in the initial design, qua initial design itself. Where I do cavil with, my lord, is that you said that the yellow roundel itself is a given. And in my submission, that's not right. It isn't a given, because I think my Lord Justice Arnold identified it. At the beginning, when one has a blank page, the decision as to whether or not to incorporate something else at all pre-existing is itself a creative choice.
Aren't you there making an assumption about evidence which doesn't exist, which is as if the stage 3 exercise was someone was given a blank sheet of paper and told to design a new Lidl logo and came up and selected something in a yellow circle and then put them all together and produce something? Well, that might well produce a fresh copyright in the whole thing, but that's not what happened, at least not unless I've misunderstood it.
Well, one has
as evidence.
Mr.
And it isn't an objective test; it's a subjective test. What did the artist actually do?
No, indeed, but the Act contemplates the probability or the possibility that one can find oneself in a situation where you have no direct evidence of the nature of the creative exercise because of the age of the work, and in this case, that was so. And what was pleaded was that we were entitled to rely upon the presumptions, provided that we ticked all of the boxes for doing so. One of the presumptions, and indeed we did do so, one of the consequences is that originality is taken to be presumed. And my lord is therefore asking for a particular kind of evidence, namely direct evidence of what was done, that is not required either by the Act or we would submit by the analysis that Her Ladyship has gone through. Because what Her Ladyship knows is that there are at least 2 options available as starting points, even once one has decided that you are going to start from a starting point. Because we know that there are at least 2 Lidl logos. There's just the word Lidl, and then there's the Littlest Billy. But I don't need even to go that far. Conceptually, my lord, it must always be the case that you start from a blank page. Conceptually, that must be right. That's always an option. And therefore, at that point, you are beginning to make a creative choice that involves the taking of other elements.
Mr. Brown, I don't. If I am wrong in my recollection of the evidence, then please do tell me. But my recollection is that what you've said isn't right. That what we're told happened is that at stage 3, the blue border was added to stage 2. It wasn't a free choice where a whole new logo was invented. I mean, if I've misunderstood the evidence, tell me.
Well, my lord, so the manner of expressing it, I think, is where we're splitting each other. As a matter of fact, that is what has happened. But it's not the same as saying that the evidence is someone was given the little logo from that particular period of time and told to add a blue square.
I'll ask a different question.
Yes.
What in your submission is the relevance or otherwise of the fact that the stage 2 logo was not in the public domain, as is now conceded? It's a copyright work owned by Lidl, but a different author at a different time with different creativity.
My lord, my response to the appeal is based on what I pleaded, which was the third work, and I don't rely upon the second work, right, in and of itself as being a basis for.
Which would mean that the yellow circle could be used.
Pardon, on its own.
Yes.
Yes. Well, sorry, rephrase it. Wouldn't be stopped by this action. No.
If someone else copies the stage 2, you would sue them for infringement of that.
We leave this courtroom, my lord, and Tesco try to get round the findings that the court has made, assuming my lords uphold it, by court.
Yeah, I understand.
What I'm trying to address is what I say is the case that was advanced, on which the judge, we say, made no error of principle but came to a perfectly plausible conclusion. But I need to address my Lord Justice Birss's query as to what the evidence showed. And just, if I may.
And that's back to Mr. Unter.
Yes, and I think it's page 75. It's paragraph 19, my lord. And as we read it, all that is known is that it was created, and it is in the form of, which is plainly right, a blue square with those circular elements and the stylized little text superimposed on it. There isn't an explanation because it wasn't known what the instructions were, what the process was. That's why we had to rely upon the presumptions under the Copyright Designs and Patents Act. One of which is, as I say, if we meet the requirements there, that originality is to be presumed. What we've sought to address is whether or not, even on my learned friend's terms, which is to say that you are just adding a blue square, whether that would be sufficient. We say that the judge would have been right to hold that that was sufficient. But in fact, there is more involved here because, and this is the point where I was cavilling with your lordship, you've got to choose to use something that already exists, then you've got to decide which one of those to use, then you've got to decide how I'm going to relate it to the other elements. And those are all creative choices that are the expression of the author and worthy of protection, but the protection is limited to the taking of those choices. And as my Lord Justice Lewison pointed out, they have been taken. And of course they were taken because, as we know, they wanted to take them because if it wasn't recognised as my client's logo, they weren't going to get the benefit that they thought was coming from it. And that's why my submission right at the outset is that we're really in Designers Guild territory here. They really cavil over the finding of copying, and so they're trying to get around it by saying, oh, well, just copied an idea. You haven't copied just an idea. You have copied the express identification of my client's sign, a sign that, as the judge had found, was highly distinctive of them by virtue of its inherent features. And so there is no surprise in our submission that both originality and substantiality fell in the same direction. Now, my learned friend says there's an erroneous reference to Ladbroke in the judgment at 287, but we submit that the reference to Ladbroke is not erroneous because the judge is specifically identifying the point in 287 that is reflected in the final part of that quote, namely that there can be, the terms that were then apparent, sufficient skill and judgment in devising the arrangements of the whole work. That can be an important or even decisive element in deciding whether the work as a whole is protected. And that, in my submission, is a reflection of the analysis that she then goes into at 289, namely, she understands that...
Well, you've got a more up-to-date instance of that, which is the Lego block analogy in THJ.
Indeed, my lord. But since we took her to Ladbroke and that's where the error is said to rely, that's why I've taken that. But I certainly don't understand that principle to be wrong. My learned friend says that it's really only applicable to works of joint authorship or as an issue of authorship. And as we say, we think that that's a red herring, so I'm not going to take you to the Dick's case because we say that's nothing to the purpose. The question is simply about this issue of whether the sign is too simple in the third iteration because it drew upon as a choice the earlier mark. We say it's an argument common to problems in philosophy, namely that it is about the significance of the framing. Artistic choices have been made. The appellant is framing them only by reference to the most obvious positive choices, the presence of the background and its shape and colour. Well, we point out that even by reference to those positive choices, there's far more at work here. Ratio, relationship, positioning being the most important, precisely the things the judge expressly talks about. But that is to describe the choices only by what can now be seen, namely the positive results. The artistic choices of rejection, not to use a particular colour, not to use stripes or patterns, or to start with a different internal shape or colour, or to have more than one shape. All those cannot be seen, but must be understood to be part of the creative process. Or to put it in more familiar terms, as every barrister knows, though not always abides by, as much effort and thought goes into what not to say as into what there is to say. Now, my learned friend offered a suggestion as to the range of options as a raw indication of creativity. And if one was to take a very, in my submission, artificial exercise, but one that he invites upon us, assume there are 10 basic shapes: circles, ovals, triangles, rhombuses, squares, rectangles, trapezoids, pentagons, hexagons, and octagons. Assume there are 12 basic colours: 3 primary colours, 3 secondary colours, 6 tertiary colours. Now you have to choose what to put in the middle. This is my point that I've had a discussion with Lord Justice Birss about. Let's limit that to the 2 earlier logos. We're already up to 240 options. That's before one considers issues like ratio, relation, the fact that there weren't just 2 options to begin with. We say that the judge's conclusion in those circumstances is entirely understandable as a matter of a value judgment. It shouldn't be disturbed. And in that regard, we do point to Paina, which is the case that my learned friend took you to. I don't need to take you to it again. Because we say there that the kinds of artistic contribution that the Court of Justice expressly referred to, the framing, the decisions as to what medium to use, and so on and so forth, these were all considered to be the kind of factors that could be relevant as matters of creative choice. And we say are present in this particular work.
I understand, so to speak, the positive choices. Not quite sure I understand the rejections. I mean, if I copy a poem by Philip Larkin, it's no answer to say, well, I could have copied one by Ted Hughes. And that's my creative choice.
Quite right, my lord, but that's about the copying. I was addressing the question of how you work out whether there has been sufficient creative effort in the creation. And when you give me the example of Philip Larkin, you give me an ideal example, because one must assume that in creating his poems, Philip Larkin didn't, as it is said of Shakespeare, just have the words flow from his pen uncrossed out, but rather gave thought to whether it should be one word or another. But when you look at the finished work, that cannot be seen, but it is part of the effort. And that is why I say it is ultimately a question of framing and of a value judgment for the first instance judge. And that what my learned friend does, my Lord Justice Birss would say good advocacy, is to talk only in terms of the positive choices. And we say that that is why it is a philosophical problem ultimately, because what do you include and what do you exclude? And we say ultimately, you ought to include the possibility, at least, of all of the negative choices. But at any rate, no error of judgment by the, rephrase it, no error of principle by the judge. And indeed, my learned friend didn't seem to suggest that it was an error of principle to take into account combination. Indeed, as you know, that debate was had at trial, it was accepted that combination could be rightly taken into account. Once you do that, you see that that's what the judge is thinking about, and takes on board, and her view is, we say, a reasonable. But consequence, substantial part, once you've accepted that there is a protectable work to that degree, then we say the answer is the one that my Lord Justice Lewison already gave. They've taken all of it. And obviously what...
Well, except my question to Mr. Cuddigan was premised on his argument that all that was protected was the blue square.
Yes.
It was in that context I suggested you've taken all of it.
Yes, indeed. Because he says you could just effectively excise it. As you understand, my submission to you is that you don't excise it, but at any event, they've taken it all. And I think where one becomes unstuck is to ask a different question, which is if they had only taken the yellow circle, where would we be? But they didn't. They took the whole of the third work, including the relationship that existed between that internal circle and the blue elements. And that's why ultimately, once you've answered the question on is there a protectable work here, the rest simply follows, because whatever it was, they took it.
Minus the text.
Minus the text, although of course one of the points we made is that perhaps here I'm on a downhill point, but they did of course keep the idea of wording across the middle. Different wording, but wording across the middle. There was a point made to the judge. I believe that she does refer to it at one point, but I certainly don't pretend for one moment that it is decisive one way or the other.
Given the point that you've made, that the relationship between the size of the square and the size of the circle and the colour of the blue are both elements of the originality that you rely on.
Yes.
Was any thought given to the possibility that not all of the versions of the blue circle in Tesco's use of the blue circle and the yellow circle and the blue background
I think
necessarily infringe, even if the one that's a square, which is of the same proportions, would?
Well, the answer is that I don't believe that the way that my Lord has just framed it, that question arose for specific consideration. First of all, because going into the trial, they just said we didn't copy at all. We had another route of origin. Secondly, because after trial, and I'm going to call it disaster of their evidence, it became we didn't copy because these are just commonplaces. But the focus was not on substantiality. In their closing skeleton argument, it receives one paragraph, and it doesn't touch upon the point you're raising. What had, however, been articulated was that issue that my learned friend Mr. Purvis referred to at the outset. What is the sign? And in that context, there had been an attempt by my side to say the sign we're complaining about is this bit, and we're complaining about it in all the scenarios in which that arises, and we accept that different words are used across it in different scenarios, but how do we convey to you that it's the same element each time that we're complaining about? And what Tesco said was, no, that's not right. That's not the sign. The sign includes the words. And we said, no, it doesn't matter because we accept that the context will always be important. So you, judge, must always take into account the words, but it's not the sign that we're complaining about. Judge decided against me on that point. You can see the discussion in the judgment, and you can see that the argument was put that way. And so in that context, my lord, what was being encapsulated is the idea that we were complaining about all of the manifestations of the use of the club card signage, even though obviously plainly they varied, apart from terms in which my learned friend has talked about, as to the words that were across them. It was never suggested, to my memory, and my junior will remind me if I'm wrong, never suggested that there was some that were in and some that were out. And indeed we say that terms in which substantiality was understood once originality had gone meant that they captured all of these issues. And certainly my learned friends think that they do.
As I understand it, the point you're making is that in closing submissions, neither side invited the judge to make a differential finding. It was all or nothing on both sides so far as infringement of copyright was concerned.
That is absolutely right, my lord.
Right.
Absolutely right. My lords, if you have bundle C, supplemental bundle C, page 793.
Supplemental C page. Which page, Mr. Barry?
Sorry, 793. It's only for your note. You can tell what's changed between opening and closing because what was in opening was in black, and what only arrived in closing is in blue. And you can see that on copying, all the talk of independent design has become the flag of Palau, but in substantial part, you've just got the one paragraph. And that's, as I understand it, what they were saying then, and it wasn't a differentiation of the kind that now seems to be discussed. I think, my lord, that brings me to the end of the discussion of the copyright appeal. If I'm wrong about that, someone behind me will jump up and down. But I was going to turn to the injunction, if my lord's content to do so. the issues on the grant of the copyright injunction, as we understand it, fall into two parts. The first is the question of whether, in the assessment of user damages for copyright infringement, it's permissible to take into account aspects of the work that go beyond the creative effort needed to make it. In this case, the specific issue is the reputation of the mark with text. I think, from the way that the oral submissions were advanced, there was a principled objection to doing so, namely that one shouldn't take into account such matters simply as a question of what fell within copyright. And that is no longer advanced. That, is, I think, was ground one. Instead, that same point re-emerges, as I understand it, as a question of whether or not, in this case, on the basis on which she was considering it, one could take into account reputation. That, if I'm correct, as a concession, we say was entirely right. It took up the bulk of our skeleton argument, and indeed, from paragraph 21 to the end, we were considering that question. It means, having gone, that I no longer need to take you through the authorities that I had identified in that skeleton argument as addressing the appropriate basis for negotiating damages. And so I will instead endeavour to pick up the issues by reference to what we understood was in issue in this case. What emerges, we say, is that one is endeavouring with negotiating damages, the second principle of damages, to identify the economic value of the asset that has been taken without licence, in order to give a value to the licence that is then presumed to arise in respect of the use that is now either in the past or ongoing. In this case, Tesco do not want the right, a licence to a right to design a work. They want a right to copy a work. They want to copy a specific work, a work with a reputation. It is because it has a reputation that they want to copy it. And the question that arises is, how much will they pay for that licence? Now, in thinking about this issue, trying to ensure that the focus remains where it should, we have sought to keep in mind a scenario where neither trademark rights nor passing off arise for consideration at all, but all the other facts are the same. My learned friend invites you to do so on the basis that the trademark and passing off claims have failed. We submit that is too limited, as I've set out in my skeleton argument. Too limited and too difficult, because it's not clear, or wouldn't be clear, the basis on which those claims have failed. Far cleaner, we submit, is to do it this way. To consider a hypothetical in which my client had no trademark registration, so no trademark infringement arose, and in which my client was a foreign supermarket, Carrefour, for example, that had an enormous reputation in the United Kingdom, but no customers. So no Hotel Cipriani style concern here. Instead, the Starbucks problem. You have no actionable goodwill in the United Kingdom, although you have precisely the reputation that my client has in this case. On the facts of that hypothetical, everything else remains exactly the same as in this case. We have a reputation. It is a reputation that is connected to the work that they want to copy, and they are copying because of that reputation. But no issue of trademark infringement arises, no issue of passing off arises. And therefore it is exactly the scenario that my learned friend invites this court to engage with. If you go to the judgment at 308, in a passage that I've already taken you to and therefore may deal with very briefly.
This is the main judgment.
Yes, sorry, my lord, I should have said 654 in Bumblebee 4B. Here the judge is explaining the context in which Tesco is commissioning the designs and explaining what the purpose of the exercise was. The exercise requiring them to look at the competitor branding and to capitalise on inferences drawn from looking at competitors and to understand how you get cut through. That motivation, we say, would have been part of the negotiation. The design that they wished to have a license to copy and to reproduce was proven to have the cut-through that Miss McKettrick was so concerned about. As our hypothetical demonstrates, no other rights need to be at play for reputation to remain part of the economic asset being licensed by Tesco and part of the motivation that they are interested in copying it for. We submit that then it becomes obvious that the reputation of the work is something that Tesco would have paid a premium for. And in my skeleton argument, I've referenced the judgment of Mr Justice Nugent, who held that you would pay more for iconic songs, even though licensed for a short period, because you knew that they would be instantly recognisable even on short exposure to an audience that they would have, if I may put it this way, cut through. The decision is the one that we refer to at paragraph 30 and is in the JA bar. We say that the conventional conclusion of Mr Justice Nugent is just that. It's entirely consistent with the rationale behind user principles, because the brand association is an aspect of the work being licensed, part of the economic value of that asset. In that case, as in this one, it is exactly what the defendant wants from the works. And in that context, we do contrast it with the situation in the Force India case, for the reasons we've given at paragraph 27 of our skeleton argument. We have made, sorry, let me take up my skeleton argument, which is behind tab 27. Sorry, I apologise, I've given the wrong reference there.
Yes, page 697, it's bundle C, tab 34.
Thank you, Mark. At paragraph 25, the 3 points that we make are, we say, all manifestations of the correct approach to user principle, user damages and negotiating damages. Namely, aspects of the economic value of the asset being licensed. One is the acquired connotations, which I've already discussed, but there are two others. The fitness for purpose, and I've shown you that that was part of the motivation, the cut-through, and the loss of exclusivity to Lidl that would have been engaged. They too form part of the valuation of the right to use the work, and therefore form part of, in our submission, the proper assessment of the licence. Now finally, in our skeleton, we turn to the suggestion that there were cheaply obtainable equivalents available to Tesco. We accept that the availability of an equivalent is a relevant consideration, but we say it is a pure question of fact whether or not there were equivalents. And we say, my lords knows that there were not. You don't need to reach to clip art or to some web browser. Tesco had in their pocket another design for a label in the form of the yellow tile, one that had been highly recommended to them by the source. No extra cost involved, but it would not be used by them. Indeed, it was described, the retention of the one that we are concerned with, as a non-negotiable. Never explained why it was a non-negotiable, but my lords know that as a fact it was. For whatever reason, those entirely free to them alternatives were not equivalent. And we say the only explanation for why they were not equivalent is precisely the matters to which I've drawn your attention, namely proven value of my client's sign, namely proven reputation of my client's sign, and therefore we submit part of the economic license that they would have been asked to take. We submit that the suggestion by my learned friend that all this could be put to one side by the now artificial process of saying, well, we know what we want to get to, so the way that we're going to copy is not by starting by telling someone copy this, but by going out knowing what we want the end objective to be and finding one and taking it for our own use. It's to reverse all of the factual findings that underpin where the judge got to on the finding of copying in the first place. And it is the explanation for why that is not what they did, why these signs were not equivalent. If my lords disagree with me on the question of whether or not, in fact, it's right to take into account in the valuation or the possible valuation at this stage, of course, ultimately that decision must be fought over, the value of the reputation, assuming we had no trademark rights to enforce, no passing off rights to enforce. We submit that what has not been addressed to you by my learned friend is whether the judge was wrong in her approach in taking into account factors other than the valuation of damages. As we submit, it doesn't follow that if you disagreed with her on that, the decision to grant the injunction is unpicked, or that no injunction should be granted at all. Her conclusion, we submit, is based on a range of factors put before her, and that can be seen on page 717. And paragraph 44. Where she takes expressly into account all of the factors that were relied upon by the parties. Specific reference to the issues I'm now going to discuss is identified at paragraph 18 on page 710 and at paragraph 43 on page 716, and therefore falls to be taken into account as part of the factors she references at 44. They are the factors that I've raised in my skeleton argument on this issue. In particular, the conduct of the defendant. That had relevance in two respects. Lidl had very early on complained about Tesco's use of the CCP sign and offered to forego any financial remedies if Tesco would simply stop within a reasonable time frame. Tesco did not stop.
So is that recorded in the judgment somewhere?
Sorry, the issue of the offer.
The offer, yeah.
Yes, it is, my lord. I thought I had the reference immediately to hand, but 43. Thank you. It's one of the two paragraphs I drew to your attention. Yes.
Right.
There were multiple stages. The first one was just, please would you stop? But then there were Part 36 offers and the response, as I say, was not to stop, but rather to ramp up the use of the sign. So when my learned friend asks you to take into account the costs of stopping now versus the damage to my client's exclusivity, it is asking the court to take into account a rod that it has made entirely for its own back. Now, in referring to Lidl's complaint to Tesco and to its offers, the court should also not lose sight of the fact that Tesco's own staff had been warning them of this potential danger. It is a significant factor, we submit, in the justice of granting an injunction that the party asking for mercy on the basis of costs of stopping at this stage has got itself into that position only by ignoring all the earlier warnings. In effect, what they now ask for, my lords, is a compulsory licence over Lidl's work not based on any of the scenarios expressly contemplated by the legislature when considering if a compulsory licence should be granted. In effect, they ask the court to write in a new basis for a compulsory licence, and that basis is, we have knowingly made it too expensive for us now to change. In that regard, we say that the grant of injunctive relief must, on English legal principles, be necessary, effective, and dissuasive. Now, those terms are obviously originally from European jurisprudence, but they've been held to be equally applicable aspects of the exercise of the court's power under Section 37, and my Lord Justice Arnold said as much in the Nintendo blocking injunction case. And our submission is that as a matter of dissuasion alone, it should not be possible for an infringer to buy its way to a compulsory licence, thereby destroying my client's exclusivity in the work in the process, and on the basis that the purchase has been made with money that it knew, because it had been repeatedly warned, should not be spent. Even if it were held that my client was fully compensated for the infringement of its copyright by a financial remedy in the terms that my learned friend suggests are appropriate, we submit to you that there remains another basis on which the injunction should be granted. That is one of general dissuasion and the justice of the case.
Now,
yes.
Is that a basis upon which the judge acted, and if not, do you have a respondent's notice?
I don't have a respondent's notice, so my submission is that it was part of the basis on which she proceeded, and that is reflected in the first line of paragraph 44, and on the fact that these were issues that have been drawn to her attention as part of the argument, and I've taken you to 43 on the question of whether or not they ignored the...
well, what about 45?
Sorry, my lord.
Where she says there's no need to consider Lidl's separate submission that Tesco has disentangled itself by its conduct from seeking damages in lieu of an injunction.
Yes.
Isn't that rather the argument you've just been pressing?
But that's by reference to the Enforcement Directive. What we submit is that at paragraph 18 of the decision, I'm making the submission about copyright being a monopoly right, that Parliament has limited in terms of compulsory licence, and that it shouldn't be possible, in order to overcome that, to point to the expenditure that you have made. That is the expenditure that's referred to at 43. That is why I submit in the first sentence of paragraph 44, she is referring to all of the matters that have been drawn to her attention, which must include what precedes it. The point that I understand her to be making at 45 is about my ability to rely on the Enforcement Directive specifically, which is why I have cast the point in terms of the English law principles on this case. But if my Lord is of the view that a proper reading of 44 and 45 precludes that as part of her reasoning.
I'm sorry, I'm sure I'm being very dense here, but I'm now confused. I thought what you were arguing was that even if the judge was wrong in terms of her approach to taking reputation into account with regard to negotiating damages, there are other reasons why she was right to grant the injunction, and in particular, you were arguing, as I understood it, and I may have misunderstood, that there was an independent basis for refusal of the injunction, specifically that this was tantamount to imposing a compulsory licence on your clients in circumstances where that wasn't something that they could have obtained, and as you put it, on the basis of dissuasion alone, an injunction should be granted.
I do understood it completely, and that is the basis on which I put it.
But where do we get that out of the judge's judgment?
Primarily from paragraphs 18 and 43, 18 being the one where I address the point of compulsory licence and the limits that the statute has put on the circumstances in which that could be granted, and 43 where I expressly address the failure of Tesco to take into account the earlier offers. I'm also reminded that at paragraph 42, albeit in a different specific context, Her Ladyship was aware of the requirements of efficacy and dissuasiveness as a matter of the basis for the grant of an injunction. I haven't taken you to 42 because she's addressing a different point there. The conclusion, though, that I say allows me to make it available to me here without a respondent's notice is that having looked at those issues at 18 and 43, her conclusion at 44 that there should be the grant of the injunction takes into account all the factors relied upon by the parties. And that is the basis on which I say it is still open to me to make it without a respondent's notice. What I understood my lord to be saying is, but look on to paragraph 45. My submission to you there is that she is dealing with a point about the enforcement directive. That is why, in making my submissions on dissuasiveness to you this afternoon, I have talked in terms of the English law principles.
But that also confuses me again. Maybe that I'm being slow. The whole basis for the argument of dissuasion is because the English courts have accepted, as the case law shows, that the criteria to be applied come from Article 3.2 of the Enforcement Directive, and one of those criteria is dissuasion. So how does it arise absent the Enforcement Directive?
On the basis that my lord held it arose absent of the Enforcement Directive in Nintendo, that they are aspects of the case law on the application of Section 37 of the Supreme Court Act, and the basis on which...
I'm sorry, I don't remember the passage in Nintendo to which you're referring, so where do we find that?
My lord, I will find it for you and I will provide it to you. It's very clear in my mind because I argued it in front of you, my lord.
Well,
and it was
may
the point,
be right.
it was the point of
I just
concern.
don't remember it.
And the reason it was the point of concern in Nintendo, and perhaps this jogs your memory, is that in Nintendo, it was the first occasion following Cartier that the blocking injunction was sought in respect to something other than intellectual property rights. And that is why one had to go outside the Enforcement Directive, because the Enforcement Directive was connected to intellectual property rights.
Yes, but the issue there was the jurisdiction of the court to grant an injunction against an intermediary who was itself not infringing.
No, my lord, that ship, as it were, had sailed by virtue of the Cartier judgment.
Well, exactly.
But
That's the point.
But the Cartier
I've
judgment...
obviously misremembered.
No, you're quite right, my lord. And rather than take the court's time now, let me just go and get the judgment. I will provide it to you, and hopefully it will accord with my memory and jog my lord's memory. But that is the reason why I'm making the distinction that I am making, because I accept that in 45 she dismisses a reliance on the Enforcement Directive. I'm saying I don't need the Enforcement Directive.
Well, you rely on the old domestic principles, don't you?
Yes.
I mean, the judges say, effectively, you've got a property right, it's been invaded. Prima facie, you're entitled to an injunction. See what she says at paragraph 4, Roman 3. I've got a discretion to refuse. I look at the Shelfer principles, although they're not determinative anymore. I look at those. I find that Tesco has not discharged the burden of showing I shouldn't grant an injunction, so I grant one.
All right, that is what I say. And what I'm teasing out in our submissions now is the different strands, and what I'm trying to point out is that Tesco's appeal has put all of its money on just one of those strands, and we say that there are others, and they need to be addressed. And
Okay, well, can I highlight the point in this way? Would you go so far as to say that even if Tesco is correct that the sum that may ultimately be awarded by way of negotiating damages is, for the sake of argument, closer to 25,000 than to 7 million, and let's not get into precise figures, because it's pointless, nevertheless the injunction would still be justified.
I hope I have already expressly said that. My note says, and I'll say it again in case I wasn't clear, even if it were held that my client were fully compensated for the infringement of its copyright by a financial remedy in the terms that you've now discussed, there remains another basis on which an injunction should be granted, and that is dissuasion.
I think there are some old 19th century cases which talk about the defendant hurrying on in the face of threats. I can't remember.
There are such cases, my lord, but we don't need to reach back to the 20th century, because court's power under Section 37 is to grant an injunction in circumstances where it's just and convenient to do so. It's plainly taken into account a number of factors as the principled application of that power. One of those must be the ones that we have advanced to now, including this idea of dissuasiveness and whether you've made a rod for your own back. We say that the judge that was argued to the judge. She says she took all of those factors into account. It's open to me now. But obviously, if my lord disagrees with me, then I haven't got a response notice, and I don't pretend that I do so. My lords, I think that at 4 o'clock I have come through everything. May I just turn my back for a moment to check that I've not missed it? Nobody is complaining behind me, my lords.
Now, I think if I've remembered the timetabling, we hear from Tesco in reply before we get on to your cross appeal.
Yes, and I think it was suggested at the beginning, my lord, that we wouldn't get to my bad faith appeal until after lunch. I have to say, I'd be quite surprised if... I'm expecting to start tomorrow morning.
Yes.
And I also understand from my learned friend that the reason why he thought I'd be able to get through it all in the afternoon is he hasn't got a great deal to say on it. And it'll be largely a debate, I suspect, between myself and Justice Arnold as to whether or not I've understood any of his judgments correctly. I'm still hoping there's still time for the Supreme Court to give its decision, is my hope, but then we'll see. But that I think, therefore, it can be dealt with by my
I remember
submission.
suggesting you might want to stay the appeal until the Supreme Court had decided Sky Kicks, but obviously that did not commence.
Well, I think, my lord, there was a point at which we understood that the judgment was going to come over Christmas or early January. I understand it hasn't yet. I also understand there's a slightly strange scenario in which you can't really effectively ask if it's about to come, because if it is about to come, you're told, I can't tell you anything. So I don't know when it's coming. My suggestion would be to the court that we do proceed with the argument, and that if the judgment comes from the Supreme Court before judgment comes down, that written submissions might be provided upon it. But we can't wait for it because we just don't know when. At least I don't know when it's going to come, and there's no promise that it'll be coming at any time.
So you're content to take the risk that we hear your cross appeal, we give judgment on it, whatever the result may be, and then there's subsequently a decision of the Supreme Court which changes the picture.
I am, and part of the reason why I am is that in my submission, that the core issues that I raise on bad faith are actually factual questions on this particular judgment, rather than issues of law that the Supreme Court is going to decide on one way or the other. There's nuance to that, as I'm sure my Lord Justice Arnold anticipates, but that's why I'm content. But also, ultimately, although important to my client, not important to this dispute between the parties. We're all here, we're all ready.
Yeah,
we should
understand. All right, thank you very much. Mr. Purvis, do you want 10 minutes now?
Well, Lords, I'm entirely in your hands. As I usually say on these occasions, probably the submissions will be made more efficiently with a bit of time to think of them overnight, but I could easily deal with a couple of points now, if that's going to help.
Well, if it's convenient to deal with a couple of points now and then have a think about it overnight, that's probably the best way forward.
Let's do that. I'll take my first 2 points and then we'll see how we go. I think my learned friend Mr. Brandreth's first submission related to, if I might call it a pleading point, that he was suggesting it wasn't open to me on this appeal to make the suggestion that the yellow circle was commonplace in retail, and that should have been part of the judge's determination of the perception of the average consumer when addressing the statutory question, and he did that by reference to paragraph 16C of our skeleton, which is at page 49A to Core Bundle B, and he said you couldn't find that point in our grounds of appeal. Just to make good that it is in fact in our grounds of appeal, if your lordships can turn back to our grounds of appeal, which are at tab 24 of the same bundle, you will see that reference in the second part of paragraph 2. Indeed, we would say what's said in paragraph 16 entirely matches the pleading the grounds of appeal in paragraph 2. I think, to be fair to my learned friend, he pressed it but faintly, but we say it's a bad point. The second thing that he turned to was to invite your lordships to consider the weight that the judge placed on the survey that was before the court that related to the question of the validity of the wordless mark registration. In other words, it raised the question of how distinctive it was separate from the Lidl branding, all part of the case, obviously on non-use and to some extent bad faith. And he spent some time on that, going through the judge's assessment of the evidence, the fact that there was an expert, Miss Sutton, I believe, and the findings that the judge made, urging on your lordships, as I understood it, that this all went to factors the judge must have had in mind when considering the overall similarity of mark and sign, and what the significance of those similarities would be to the average consumer, given the reputation of the mark. Can I just take you in that respect to explain why it's not actually the case that the judge relied on this, or indeed could have relied on it, given the nature of her findings when turning to the question of similarity of mark and sign, which, as your lordships understand, is essentially the blue square and the yellow circle alone. She turns to it in paragraph 224, where she is considering as a fifth point in support of the finding that the wordless mark, despite the fact that it hadn't literally been used, had nonetheless established a reputation or acquired distinctive character. She kicks off very specifically by identifying what the distinguishing character of the wordless mark consists of or derives from, and is very clear to point out that it derives from the very particular combination of colours and shapes, the yellow central circle surrounded by a thin red ring. I think my Lord Justice Lewison made that point in passing about what the wordless mark comprises, both centred within a blue square. I agree with Lidl, these elements aren't altered by the presence of the word Lidl, just as the power of the wordless mark to denote the business and goods of Lidl doesn't appear to be affected by the addition of that word. She goes on to consider the argument that word elements are more distinctive, a reference to Specsavers, but concludes in the last few lines, I reject the suggestion the wordless mark is a banal trite or commonly used background. none of Lidl's competitors uses a similar mark to note their businesses or brands, although there is evidence of yellow circles being frequently utilised as a means of indicating value. I am here concerned with the very specific combination of features which makes up the Lidl logo, not with individual features taken separately. The obvious point is that nothing here to support any proposition that would relate to blue and yellow alone, because blue and yellow alone was not the specific combination of colours and shapes which the judge has very carefully pointed out in 224 was the subject of the wordless mark and was the basis of her finding of its distinctive character. And of course, a fortiori, she wasn't considering the position of whether it, what the distinctive character would be if it had other text.
Can you help me on that? My recollection, it may be faulty, is that when one looks at the Vox Pop messages that are relied on by Lidl, and I appreciate you've got a whole series of other submissions about those, but just concentrating on this point, they rely upon a variety of them mentioning blue and yellow, and effectively the message is blue plus yellow equals Lidl. Now that's a bit of an oversimplification, but I don't recollect any of them mentioning the red circle, do they?
Well, of course, they're not looking at, as I understand it, they're looking at what Tesco have put forward. Of course, what Malone and Friend tries to rely on is that some of them mentioned that it conveyed a connection to Lidl. The point I'm making here is not about that, which is an argument, and we'll come back to Malone and Friend's submissions about that. But the point here is a very specific one, that he's attempting to draw support for his submissions from actual findings of the judge and trying to transplant them into another part of the judgment, as it were, which is concerned with the evaluation of the risk of a particular message being drawn from Tesco's brand. But of course, the judge is first of all not looking at a wordless mark with club cards written in the middle or anything of that kind, or indeed any text written in the middle. And also she is very specifically talking about the specific combination of features.
Well, that's undoubtedly correct. Do you say that this finding is irrelevant?
Yes, we say it can't help him. Because unless the judge is asked to make a finding about a different wordless mark, which comprises yellow in blue and nothing else, it can't help him. And in fact, even that finding doesn't go very far, because of course that branding doesn't have anyone else's trademark written in the middle. I mean, we say this whole thing is it's a completely different issue. The judge is properly looking at it in the right way, which is to look at the entire combination of features, and indeed that is what Malone and Friend was urging the judge to do, because it helped his case on the question of the Specsavers test and whether it had acquired distinctive character, even though it had only been used with the Lidl logo. My Lords, I said I'd make 2 points.
You did?
I have done, and I have almost got to 4:15.
All right,
So, with that,
we'll stop there and we'll start again at 10:30 tomorrow.
Right.
Court rise.